Good morning, everyone. Today, we're taking you back to 2016, when a locked iPhone sitting in an FBI evidence room triggered one of the most consequential legal and technical standoffs of the modern era. We're calling it the sovereignty of silicon. The story of what happens when national security runs headfirst into the mathematics of encryption.
You're about to see a completely different case, and maybe actually a completely different presentation from the ones that you've been seeing. Our case shows negotiations beyond the things that we've been practicing, beyond just the FBI against Apple and seeing how they negotiated between them. Rather, this is a case that represents the question of how can you negotiate with a party that is telling the public that they should win because thousands of people died and therefore they're right. So this case isn't about how to negotiate and how maybe they negotiated between them, but number one, how they negotiated inside of the courtroom, which was the information that we could find, and also how they negotiated against the public eye. Before we get into the crisis itself, it's worth pausing on who these two parties actually were in 2015, because neither is the institution you might have pictured today. On the Apple side, Tim Cook had been CEO for just 4 years, and he was still fighting the perception that he was a capable operator, but not a visionary. Privacy was becoming his answer to that question. In 2014, iOS 8 shipped with full device encryption turned on by default, the first time Apple had done that, and the FBI complained about it immediately. So by the time San Bernardino happened, the collision course had already been set. On the FBI side, Director James Comey had been formally articulating what the Bureau called the going dark problem since at least 2014, the argument that encryption was systematically blinding law enforcement to criminal activity. These known revelations in 2013 had badly damaged public trust in federal surveillance, and Congress had repeatedly refused to update wiretapping laws to cover encrypted software. The FBI was institutionally frustrated, legally constrained, and looking for the right case to force the issue. San Bernardino gave them what they thought was an unanswerable one.
So, three things define this case. First, we have a legal crisis. A terrorist attack in San Bernardino forced a very public collision between the government's demand for access and Apple's superior architecture. Second, we have the technical impasse. So the FBI wanted what they internally called government OS, which is a modified iOS version that bypasses security. Apple called that a titanium onion that they were unwilling to peel. And third, we have the Daniel legacy. 10 years later, this case still shapes encryption law globally and the going dark debate, and we are going to work through the three of them. So, December 2nd, 2015, two people opened fire at the Inland Regional Center in Bernardino, killing 14 people and injuring 22. They were killed in a subsequent police shootout, but before they died, they destroyed their personal phones. However, they missed one, a work-issued iPhone 5C belonging to one of the shooter's employers, San Bernardino County, and was recovered intact. The FBI believed it might contain encrypted communications with co-conspirators, radicalization timelines, and maybe more. So that phone became the center of this historic confrontation, and this is where the case begins. We'll now show you a brief video summary of the issue and how it all happened. We used our research as a source of information to feed an AI video maker that will help us illustrate the case so it's more digestible.
Off one, which sets up the meeting of the Titans. So, the inciting incident drops us straight into this totally sterile conference room. The script fittingly dubs it the walled garden. Right in the center of a massive white table sits a locked iPhone 5C belonging to a terrorist. On one side of the table, you have a totally harried FBI agent Smith. On the other side, a completely serene Apple CEO stand-in named Tim, wearing his signature black turtleneck, and he's sitting next to a very nervous tech engineer. Now, Agent Smith opens the negotiation with what honestly seems like a perfectly rational, straightforward point. He notes that the phone only has a 4-digit passcode, right? That means there are exactly 10,000 possible combinations to try. From the FBI's perspective, this should be a walk in the park. As Smith puts it, a monkey with a number pad could guess it in an afternoon. But there's a huge catch here. The device has built-in defenses specifically designed to stop that exact kind of brute force guessing. And this is where we get that brilliant technological divide. The Apple CEO stand-in, Tim, famously pushes back on the FBI's simplistic view with this incredible, vivid metaphor. He calmly explains that the FBI just fundamentally misunderstands the integrity of the system. To Apple, the iPhone isn't just a basic combination lock on a gym locker that you can just keep spinning until it pops open. No, it is a titanium onion. And according to Tim, you simply cannot peel a titanium onion. Which brings us to the actual crux of the issue. The FBI basically wants a digital magic wand. They want a switch flipped to bypass the security entirely. Agent Smith demands that Apple write a highly specific piece of software. The nervous Apple tech guy whispers that they call this theoretical switch GovKios. Basically, the FBI wants Apple to build GovKios specifically for this single phone's A6 chip, so that the software will just completely ignore the passcode counter. If the phone ignores that counter, the FBI can just rapid-fire guess all 10,000 combinations without the phone wiping its own data. It is technically possible, sure, but as a tech guy points out, it's dangerously irresponsible. Apple's argument is that creating this backdoor is literally like introducing a digital cancer into the ecosystem. Tim completely shuts the request down. He explains that once you write the code for a master key, it exists out there in the real world. It could be stolen. It could be leaked. You wouldn't just be opening one terrorist phone. You'd be compromising the fundamental security of hundreds of millions of innocent users all around the globe. For Tim, this is way bigger than one device. It's about protecting what he dramatically calls the sovereignty of silicon. When the technical arguments hit an absolute brick wall, the impasse escalates from a philosophical debate to a very hard legal standoff. The FBI quickly realizes they can't just appeal to Apple's sense of duty, so they try a much more forceful approach. They try to literally brute force the negotiation by offering cash. They estimate what an Apple engineer's labor cost would be to write the GovOS code. Agent Smith announces that, according to their analysis, an Apple engineer could bang out this bypass code for as little as $100,000. He completely frames it as a simple matter of compensating them for their time and effort. But Tim basically says you cannot put a price tag on privacy. It's totally non-negotiable, because Apple would have to actively dismantle core security features and risk systemic global harm. Tim looks Agent Smith in the eye and tells him he's confusing value with principle. Apple's stance is anchored in the hard reality of the request. They wouldn't just be typing up a simple script. They'd have to actively tear down core security features they spent years perfecting. We're talking about removing auto-erase functions and eliminating the rate-limiting deletes that physically stop hackers. It's an undue burden that goes against everything the company stands for. And here is where the real legal fireworks go off. Frustrated, Agent Smith slides a piece of paper across the table, attempting to legally compel Apple using the All Writs Act of 1789. He very proudly points out that George Washington himself signed the law giving them the basis to force Apple to hack its own phone. But Tim, he just casually slides the paper right back. He argues there's absolutely no way a centuries-old gap filler statute can force Apple to write destructive code. Why? Because writing code is a form of speech. Under the First Amendment, the US government cannot force compelled speech. Tim just coolly suggests the FBI go take it up with Congress instead.
So what exactly were investigators dealing with? The iPhone 5C runs on the A6 chip under iOS 9. Now here's the key technical detail that matters for everything that follows. This model lacked Apple's Secure Enclave, the dedicated security code processor introduced in the iPhone 5S. That meant that its passcode protections, the auto-erase counter, and the rate-limiting delays were enforced entirely in software. The FBI saw that as a potential opening. The device was locked with a 4-digit passcode, meaning 10,000 possible combinations. Now, under normal circumstances, you'd never get through them. 10 wrong guesses, and all the encryption keys are gone permanently. This slide gets at why Apple framed its position the way it did. 3 hardware and software constraints made this phone essentially impenetrable. Firstly, auto-erase. 10 failed attempts and the cryptographic keys were destroyed. The data would be gone forever. Secondly, rate limiting. iOS enforces escalating delays between attempts, up to an hour per guess, making brute force attacks completely impractical. And finally, code signing. The iPhone hardware will only accept software signed by Apple's private cryptographic keys. And that last point is critical. It's what the FBI needed Apple to exploit. No other party on Earth could push a software update to that phone. Only Apple.
And before the legal battle even started, the FBI made a critical mistake. In the hours after seizing the phone, they directed San Bernardino County, which is the device owner, to reset the iCloud password. The intent was to download a fresh backup from Apple servers. But because the password was changed while the phone wasn't connected to a known Wi-Fi network, it couldn't authenticate with iCloud to trigger said backup. Apple engineers later testified that if the password hadn't been reset, they could have simply brought the phone near a familiar Wi-Fi signal and pulled the data automatically. No court order, no legal battle, no government OS. That 24-hour window was the biggest missed opportunity in this entire case.
So when technical collaboration failed, both sides moved into legal terrain. Let's look at how each party fought this. The DOJ's legal strategy rested on the All Writs Act of 1789, a colonial area statute that serves as a gap filler, allowing federal courts to issue orders necessary to carry out their jurisdiction when no specific law applies. The argument? We have a valid search warrant, so the court can compel Apple to provide reasonable technical assistance. To soften the burden argument, the FBI even offered to pay Apple for the engineering time, framing this as a simple, narrow, one-time administrative task. The map on screen shows the jurisdictions where Apple and Google filed supporting briefs, and this wasn't a fight Apple was fighting alone.
The FBI's task broke down into 3 specific software modifications. 1, the bypass erasure. Modify iOS so it never deletes encryption keys, regardless of how many wrong attempts are made. 2, electronic entry. Allow passcode guesses to be submitted programmatically through the Lightning port or Bluetooth, not just manually on the screen. And 3, remove rate limiting. So eliminate the enforced delays between attempts, so the FBI computers could just run thousands of iterations in minutes. Apple called this hypothetical software government OS and said that while it was technically possible for an iPhone 5C, creating it would be far too dangerous to ever exist. On February 16th, 2016, the same day that the court order was issued, Tim Cook published an open letter to Apple customers. He made it very clear that this wasn't going to be handled quietly. He wrote that the US government had demanded Apple take an unprecedented step that would threaten the security of its customers, and that the implications went far beyond the legal case at hand. So by going public immediately, Apple changed the entire nature of the dispute. They got the ball in the court. It was no longer just a court case, it became a national conversation.
Apple's legal team, led by former US Solicitor General Ted Olson, mounted a 3-pronged constitutional defense. First, the First Amendment. Computer code is actually protected speech, and compelling Apple's engineers to write a security undermining code is unconstitutional compelled speech. Secondly, the Fifth Amendment. The government was effectively conscripting a private company to act as a state agent, an innocent third party forced into service. And finally, a separation of powers argument. Congress had already considered and declined to pass legislation mandating encryption backdoors, if you remember from my first slide. The FBI was using the courts to do an end run around the legislative process. Each of these arguments expanded the stakes well beyond a single criminal case. And the reputational stakes were real. A Pew Research survey from February 2016 found that 51% of Americans sided actually with the FBI, while 38% sided with Apple and 11% were undecided. The emotional context of a mass casualty terrorist attack, still fresh in the public consciousness, naturally leaned opinion toward law enforcement. But notably, tech-savvy demographics and younger respondents skewed it toward Apple. The fact that Apple held 38% support against the backdrop of a terror investigation tells you how effectively Cook's public letter had reframed the issue from help catch terrorists to protect everyone's privacy.
And beyond the courtroom, let's talk dollars. We'll discuss Apple in the short term and what to earn them over the long term. During the six-week legal battle from December 2015 through mid-February 2016, Apple stock fell roughly 19 to 30%, depending on the benchmark period. And market analysts noted that much of this was tied to broader saturation concerns in the smartphone market, but the legal standoff added a layer of geopolitical risk that definitely accelerated a sell-off. And the concerned investors' flag was this: if Apple was seen as having cooperation agreements with the US government, then their key international markets, particularly in China and the EU, might conclude that American technology is compromised, and that was a supply chain and revenue risk, not just a PR problem for Apple.
Now, here's where the story gets interesting from a strategic standpoint. Apple's refusal to comply turned into a long-term competitive advantage. By 2024, Apple's market cap exceeded $3.2 trillion, supported in large part by consumer trust in what the company calls its walled garden. The 2016 stand became the foundational moment for Apple's positioning of privacy as a product feature, not just a legal obligation. That trust had fueled the high-margin services business, like iCloud, Apple Pay, and the App Store, which now exceeds 70% gross margins. And competitors like Google scrambled to match Apple's privacy messaging. This slide highlights three outcomes: the $3 trillion threshold, privacy as a product, and the competitive moat. Apple won the long game. Now, this case wasn't just about one company and one phone. The UN High Commissioner for Human Rights warned at the time that an FBI victory would effectively hand a blueprint for digital repression to authoritarian governments worldwide. Encryption isn't just a convenience feature. For journalists in countries where dissent is criminalized, for activists, for whistleblowers, it is the only barrier between communications and state persecution. The argument Apple and its supporters made was this: you cannot create a backdoor that only the good guys can use. The exploit that unlocks Farouk's iPhone, which is the terrorist iPhone, in San Bernardino is the same exploit that could be used by a government in Beijing or Moscow. And that's not a hyperbole. That is the definition of cryptography.
Now let's look at how each side played the negotiation, because this is a masterclass in strategy and in its limits too. Apple deployed three tactics simultaneously. First, the power anchor. They refused to engage on the merits of any compromise and instead anchored the entire debate in one immovable technical fact: a safe backdoor is mathematically impossible. There is no middle ground to negotiate toward. Moral crusading. Cook transformed what could have been framed as corporate self-interest into a defense of human liberty, building a coalition that included Google, Meta, ACLU, the EFF, and international human rights organizations. And that coalition essentially neutralized the FBI's attempts to isolate Apple as unpatriotic. And lastly, we have the public pressure. The FBI tried to use a horrific tragedy as leverage, and Apple countered by reframing the risk as not just one phone, but 1 billion active devices. The FBI was essentially fighting a battle of emotion, while Apple was fighting a battle of scale. In hindsight, there were at least 3 points where this entire confrontation could have been avoided or resolved more effectively. First, we have early collaboration. The iCloud password reset is the original sin of this case. Had the FBI not ordered that reset, Apple could have triggered an automatic backup over Wi-Fi, like we mentioned previously, and the data would have been obtained without any court order. There wouldn't be any legal precedent and no public battle. So that's number one. And then we have the internal sync as number two. We now know from the OIG report that the FBI's own remote operations unit was approximately 90% of the way toward a technical solution before the legal case went public. So if the FBI leadership had better cross-unit communication, they would have known that a technical path did exist and never initiate this legal escalation. And third, we have legislative clarity. The DOJ reached for a 237-year-old statute because no modern law covered the scenario. Congress had considered and declined to mandate encryption backdoors. Formal lawful access framework debated openly in the legislature would have been far more durable than a court order under the All Writs Act, and far more legitimate in the eyes of both industry and also the public.
The resolution was abrupt and, frankly, anticlimactic. On March 28, 2016, one day before a scheduled court hearing, the DOJ announced it had successfully unlocked the phone through a third party and withdrew the case entirely. The contractor was Azimuth Security, an Australian firm. Two of their researchers, Mark and David, developed what they called Project Condor, an exploit chain that used a vulnerability in open-source Mozilla code Apple used for Lightning port accessories. Chaining that with two additional exploits gave them full control of the iPhone's application processor, allowing them to test passcodes without triggering the auto erase or the delays. The FBI paid approximately $900,000 for this one-off solution. No legal precedent was set, and no constitutional questions were resolved. The case was just dropped. So, what did $900,000 actually buy? The phone was unlocked. The data was reviewed, and investigators found, quote, nothing of real significance related to the terror plot. The perpetrators had been killed, their personal devices destroyed. The work phone was a dead end. Meanwhile, the constitutional questions the DOJ hoped to settle, whether a company can be compelled under the All Writs Act to write security undermining software, remain completely unresolved. That a legal lacuna that had persisted for a decade. No binding precedent, no legislative fix. The FBI got a one-off technical solution, paid 6 times what they claimed that Apple's engineering would have cost, and got nothing strategically out of it.
The 2018 DOJ Inspector General report added another painful layer to this postmortem. 3 findings stand out. The line in the sand. The FBI's remote operation unit, their hacking team, had a vendor who was 90% of the way to a solution, as we mentioned, but their internal policy discouraged using national security tools in criminal cases, so that knowledge never surfaced the decision-making chain. Number 2, the communication failure. FBI units testifying to Congress were completely unaware of this progress, leading them to make claims about impossibility that were simply not true. And the strategy clash. Some senior FBI leadership were reported to be disappointed with the Azimuth solution because it ended their chance to use this case to set legal precedent for future surveillance authority. The legal battle ended, the phone was open, and almost nothing was resolved. The final section covers the actual settlement, what the FBI found, and what the OIG later uncovered about the FBI's own conduct, and where the encryption debate stands today.
10 years out, the encryption debate has moved on, but it hasn't resolved. 3 major elements define where things stand as of 2026. First, end-to-end encrypted backups. In 2022, Apple launched Advanced Data Protection, finally encrypting iCloud backups with keys that Apple itself cannot access. This closed the workaround that law enforcement had used for years, getting data through iCloud subpoenas because Apple held those keys. That door is now shut. Second, UK pressure. The UK government issued a technical capability notice under the Investigatory Powers Act in mid-2025, demanding a backdoor to Apple's iCloud backups globally. Apple challenged the order and threatened to pull iMessage from the UK market entirely rather than comply. Finally, EU chat control. The EU SAR proposal, which would have mandated client-side scanning of end-to-end encrypted messages, has largely stalled, but the debate continues. The crypto wars haven't ended, and they've just moved from device storage to message transmission and cloud data. Looking ahead, 2 forces will reshape this debate entirely. First, Apple's intelligence and AI integration. Apple's on-device AI features require new privacy architectures. They've introduced what they call private cloud compute, where AI processing happens in an isolated cloud environment where even Apple can't see the data. Critics argue that this creates new attack surfaces. The partnership with OpenAI raises additional questions. Second, post-quantum cryptography. Current encryption standards, including the AES-256 underpinning everything we discussed today, will eventually become vulnerable to sufficiently powerful quantum computers. NIST finalized PQC standards in 2024. The transition will define the next decade of security architecture. The FBI Apple case taught us that when the law collides with math, math wins. Post-quantum cryptography will test that lesson again at a completely different scale.
Our primary sources include the 2018 DOJ Office of Inspector General's Special Inquiry, the Washington Post, and Reuters' investigative reporting on Project Condor, and Azimuth Security. Thank you.
I wanted to include a bonus feature at the end of this video explaining for about 1 to 3 minutes how we can connect what we just learned about with the concepts in the class. So specifically, we see here 3 main issues: a negative SOPA, a lack of a BATNA, which sounds weird and I will explain that, and finally, the position of power and how each of the parties use power to persuade the other side. So you would assume that a lot of negotiations took place outside of the courtroom, and although we found information on that and we included it in the slides, it quickly turned into a legal issue. That is because of who had the power. You would think that the government and therefore the FBI had the most power because they can tell people what to do. But if you remember your constitutional rights and how companies work, the government can't exactly force people or companies to do something. And that's how Apple changed the power dynamics to then hold it themselves by taking it into the courtroom and saying, as the government, you can't tell me what to do. And I actually have the power because I have the key to this titanium onion that we created. And so that's how the negotiation turned out. But then we see here something interesting, a negative SOPA. Apple's saying, I don't want to help you. This would be a complete breach to cybersecurity and everything else. And the FBI is saying, you need to help me because I don't have a BATNA. But that's weird. We know from this class that everyone always has a BATNA, and if you claim that you don't have one, then that means that you just haven't looked hard enough or thought hard enough about it. And in reality, we see from how the negotiation turned out that they didn't have a BATNA, this $900,000 solution from Australia that was able to get into the iPhone. And if they had known about this, maybe they could have changed this negotiation from a negative SOPA, where one party did not want to comply and the other one really needed help because they didn't have a BATNA, to then a positive SOPA, understanding you have something that is going to breach into my solution as Apple and the iPhone, and therefore let me see how I can help you instead of you trying to go outside of the States to find a solution. So, in conclusion, if you ever find yourself in a negotiation where there seem to be no BATNAs and a negative SOPA, I would recommend to stop negotiating and ask the other party and yourself, can you try to find a BATNA? Do you really not have one? And if so, and if you do, how can we turn this from a negative SOPA to a positive one? Specifically, could we create contingent agreements to lower risk? Could we create other agreements or post-settlements as well to see how we could both benefit after we settle from this? Any of the tools that we have learned could have been applied to this case. And yet, by not communicating well and not trying to understand the other party's side and interests, and rather solely focusing on roles, I think that the negotiation didn't turn out well. And we see that because there wasn't one. The FBI ended up just dropping the case, and we ended up with more questions than answers. So, as a conclusion, remember to focus on the interests rather than the roles, and try to find a BATNA and a positive SOPA. Thank you.